Now, to gain a better understanding of what's going on within Reggie's mind and to gain a clearer picture in your mind as a whole, I think it's important to go over the law and what's going on within the trial itself. At this point in time, very few states within the US actually had laws against texting while driving or talking on the phone while driving, and Utah was not one of them. That meant that when prosecutors came after Reggie, it wasn't for what you typically expect. In fact, the charge that they brought against him was only a Class A misdemeanor, when usually they would end up charging someone with criminally negligent homicide as a felony instead. Reggie Shaw was only charged with negligent homicide. That means that his sentence at most would only be a couple of years. Now, it also means that there wasn't much precedent. In Utah, there had been some cases involving civil lawsuits and liabilities for damages, but never a criminal trial against someone. That meant that there were also issues with determining expert witnesses. What is it they could actually testify to? What is it that was truly based on necessary and relevant information, and what was overly cursory and too prejudicial to present to the jury? On that matter, the defense argued that when the prosecution brought forth an expert that wanted to testify on several matters, one of which was that texting while driving brought forth a six-fold increase in the chance of crashing, two, that texting while driving was akin to driving under the influence, driving drunk, and three, that the likelihood that Reggie had hydroplaned that night was next to zero. Now, the defense wanted to argue, first of all, that this information was very new and that someone like Reggie couldn't have possibly known it. This kid's only 19. There's no way that he should be expected to know things like this when the general populace doesn't even know it themselves. People so often text and drive. I mean, come on, everyone sent a text once in a while, right? The amount of people you can see just by walking outside being on their phone while they're driving is quite incredible. To bring all of that to bear against some kid is just far too much. Furthermore, bringing up evidence like drunk driving being the same as texting when this information is so new could very easily be wrong in the future, and then could prejudice the jury against Reggie when in the future he could be extradited. On the other side, the prosecution argued that it was up to the jury to decide whether or not Reggie should have known, and that is true. They argued that what their expert wanted to testify to was just the facts. It's a fact that texting while driving increments a six-fold increase in the risk of crashing. It is a fact that the chance that Reggie's story was true, that he hydroplaned, was next to zero, and that it was up to the jury to decide whether or not these were relevant and whether or not Reggie deserved it. Now, in terms of what actually happened, all that really matters is what the judge says. Overall, the prosecution did win, but the judge made some good judgments in favor of the defense as well. First of all, he ruled that any mention of texting while driving being akin to a DUI was substantially more prejudicial than it was probative to the jury. As such, no mention of that could be made. However, the idea of whether or not a lot of the other research that the doctor had actually presented, because it was so new, was still up in the air, and in fact would have to be decided almost right before the trial date at the final pretrial hearing. Now, before that could ever happen, the prosecution offered Reggie a plea deal. That plea deal was that, first of all, that Reggie would serve up to 90 days in jail. Two, that he would complete community service work in the form of telling others about his tragedy. And three, an agreement to testify in the future for any legislation that might be introduced into the Utah Congress in order to ban texting while driving or using a cell phone while driving in general. Reggie, having heard all of the things before him, he very much questioned his own state of mind, and he decided that his own recollection of events, that his own memory that he had hydroplaned was in fact false. As such, Reggie, going through quite a lot, and registering a lot of the error, decided to take it. What that meant is, for him, not a bad deal. I mean, he did kill 2 people, so getting away with 90 days in jail, which would actually only become 30 days, was pretty good for him. However, some of the things I think he simply could not have known in the future. Part of this plea deal is that it was a deal in abeyance. What that means is that Reggie's permanent record would eventually be wiped clean after he had completed his service work, after he had given his presentations. But when you're the poster child for texting while driving, it's not really ever going to go away. And in fact, Reggie continues to do his presentations to this very day. On that note, and knowing what you do now about Reggie and what's going on with those around him in the trial, do you think that Reggie was just someone like a scapegoat, something that was necessary to happen so that people in the future could get better justice for the victims of other people who are negligent on the road? Even today, we now have so much evidence in the palm of our hands, everywhere we go, that texting while driving is dangerous, that it's just as bad as drunk driving or driving high, etc., etc. But yet, you could still walk outside and see people do it. I just walked home from one of my classes and I saw someone do it. Is Reggie just unlucky? Was he just unlucky enough to be the first of those around him to be prosecuted for this crime? And is it fair that he's now marked for the rest of his life because of it?